Today we are going to talk about the criminal justice system and the procedures. What is criminal justice system? It is a network of government and private agencies intended to manage the accused and the convicted criminals. Criminal justice system addresses the consequences of criminal behavior in the society, and its objective is protecting people's rights to safety and the enjoyment of human rights. It refers specifically to the network of police, prosecution, and the judiciary with regard to criminal matters, as well as access to legal aid, prisons, and alternative to imprisonment, restorative justice, and the victim protection and reparation. The procedure followed in the criminal justice system is very important, because it is only by following a certain procedure that fairness is seen to be done. So criminal justice system being a process is actually a process from the time one is apprehended by the police identifies him or herself with an ID and explains the reason for apprehension. The suspect is taken to the police station where an accusation or charges are open to him or her in the daily occurrence book, which we also refer to as OB, in the police station. Depending on the charges preferred against the suspect, he or she is required to write a statement voluntarily on his or her own or in the presence of his or her lawyer. The suspect can also refuse to be interrogated by the police until his or her lawyer is called, because anything you say during the interrogation with the police can be used against you in a court of law. So it is not a must, you the suspect, that you must talk to the police. You'd say, no, I'm not ready to talk until my lawyer is here. So this is a condition called the Miranda Principle. Remember, silence is a weapon. Now, once the suspect has given his or her statement, he can be locked up in a police cell or released on a police bail, depending on the seriousness of the offense, with a surety which can be in form of cash. Sureties can also be car logbooks, title deeds, and any other property in the name of the accused. So the bail is to ensure that the suspect is set free as the compilation of the court file is prepared, and that should he fail to honor the court summon to appear in court, the bail is forfeited or a warrant of arrest is issued by the court. If the suspect is not able to raise the cash bail or a police free bond, he is locked up, but must be presented in a competent court within a period of 24 hours. Unlawful detention of a suspect beyond 24 hours is illegal unless extra detention period is obtained from the court. Unlawful detention of suspect beyond the stipulated time is referred to as habeas corpus, and the suspect can sue for unlawful detention. Once the court file is ready, it is presented to the court registry, where it is booked, and the summons to appear in court are issued to the suspect. So let us look at the principles or tenets of fair trial. Fair trial is important in order to protect the rights of the citizen enshrined in the Bill of Rights of our Constitution. The accused does not cease to be a human being because of the criminal act he has committed, but the court intention is to correct the wrongs, make accused remorseful, and if possible, compensate the complainant or the plaintiff for the damages done to him or her. Thus, both the complainant and the accused or the defendant have the right to fair trial so that they have confidence in the justice system and also adhere to the law. Failure to this, there is likelihood of lawlessness in the society and a challenge to govern. So the principles of fair trial. One of the principles of fair trial is presumption of innocence until proven guilty. What this one means is, even if you are apprehended by a law enforcement officer and taken to the police station and all that follows, the law enforcement officer should not treat you as a guilty person. This can only be proven in a court of law, whereby the defense or the prosecution will bring or table down evidence against the accused, and if there is sufficient ground that you have really committed this offense, then that is the work of the court to decide. The court that is actually presiding over should also be independent, impartial, and comprised of competent judge or magistrate who should be appointed by a competent court. Why we are saying independent is because sometimes you may find there are cases whereby, although the court is presiding over the case, there is already a predetermined outcome because there is influence coming from elsewhere. So the judge or the magistrate will not have the freedom to make a fair judgment. So that is why there is need for independence in the court. And also, being impartial, you should not have a predetermined outcome. You have to listen to the evidence from both the prosecution and the defense, and it is out of that and the weighing in the scale of justice that you see whether the evidence presented to the court by the prosecution and the countering of the defense, looking at the both sides, which of the two sides have the weight, and if there is enough proof, then that is the time the judgment of guilty or not guilty can be entered by the court. There is also need for quick and expeditious hearing and determination or judgment of a case, since justice delayed is justice denied. You may find in certain situations, especially when the accused feels that there is sufficient evidence to convict him or her, he may talk to the lawyer in order to keep on delaying the case using flimsy excuses, so that there is that element of adjournment of the case over a long period of time. There are cases that have stayed in court for over 10 to 20 years, or some to eternity, whereby even the complainant dies before the judgment is given. So that is not fair to the complainant. So there is need at least to conclude these cases within a reasonable time, so that both parties may feel that there is fairness in our justice system. The hearing of the cases should also be done in open court, and there should be public participation. This is important so that even the public can hear the accusations and the counter accusations, and there is also the public judgment. They can be able to tell, so that when the judge gives the final judgment, then the public will feel, yes, our criminal justice is fair to both the accused and the complainant. Although there are certain cases whereby they cannot be brought into an open court depending on the sensitivity of the matters. Like now in cases of abuse of children. You don't expect a child to be brought to court and everybody is watching and listening to what the child is saying. So some of these cases are heard in camera as a way of protecting the witnesses. There are also other cases where witnesses fear to appear before the accused because the accused have an idea who they are. So in such cases, the cases are heard in camera where the voice of the complainant is distorted so that the accused cannot be able to tell who is giving the evidence. So the trial should also be done in the presence of the accused, and he or she should have the knowledge of the accusation or charges preferred against him or her, and it should be given adequate opportunity to prepare for his or her defense. Before the promulgation of the 2010 Constitution, sometimes the accused could be ambushed by the complainant or the prosecution with evidence that he is not aware of. So you may find sometimes he has no time to defend himself. To make the whole system fair, it is made in such a way that the accused is given the charges preferred against him or her well before the date of hearing, so that him or her and his defense lawyer can be able to have sufficient time to prepare for their defense. So the charges and accusations that are made against the suspect should also be made in a language that the suspect or the accused is able to understand. Otherwise, if the accused cannot be able to understand what he or she is being accused of, then the end outcome will not be fair. So to ensure that the accused is able to understand the charges leveled against him or her, there is need to have an interpreter, so that the interpreter can be able to tell the accused, this is what the charges leveled against you are, and at that point the accused may agree or deny. And also, if the suspect cannot be able to hire a lawyer, it is the responsibility of the court to hire a lawyer for him or her, especially in serious cases whereby the suspect may not be able to understand the magnitude or the consequences of the outcome. Of course, before the court hires a lawyer for the suspect, they'll have to do some due diligence and do some consultation so as to be sure that this person has a financial challenge and he may not be able to hire his or her own lawyer. And in that case, the court hires a lawyer for him or her. This is not a favor. It is there in the law. It is until the accused have had an understanding of the kind of offenses he is being accused of and the consequences that he or she should, and the consequences of these cases that he or she should now accept to take a plea. Taking a plea means accepting or denying the charges leveled against him. There are situations where people the accused outrightly accept that they committed the offense. But considering the magnitude of the offense, the court gives him another chance to go and think about it, especially if the offenses involved are of serious nature, like murder, rape, arson, just to mention a few. And also, on the same note, depending on the seriousness of the offense, the suspect is supposed to undergo psychological assessment to know whether this person is competent enough to stand trial and whether he understands the magnitude of the offense that he has committed. So it is only after psychological assessment and the medical report shows that he is competent enough to stand in a court of law that his plea of guilty or not guilty is accepted by the court. If the suspect is found guilty according to the weight of the evidence presented by the prosecution through examination and cross-examination, the suspect is convicted for a jail term in prison or that is the correctional system, or given an option of a fine which would commensurate the nature of the offense. If the suspect cannot raise the requisite fine, he or she is locked in prison until the said fine is paid. If the evidence presented by the prosecution is watered down by the defense of the accused such that it does not meet the threshold, then the case is dismissed and the accused person is acquitted or set free. The acquittal or conviction marks the end of the case in the criminal justice system.